Yes, I am.
You take?
There's an instance that I can refer to when I was virtually dragooned to appear before the minister to go to her office, that I needed to have a one-on-one with her. And my meeting took place at 6 o'clock in the morning. And what transpired then, of course, was that the minister was not there. Instead, it was a legal advisor and one of the employees, I think it's the chief of staff. Our document was flashed to me to say that these are my misdemeanors that I had committed. I arrive late at meetings, I'm disruptive in meetings, and I have ambitions of becoming the group chief executive officer and all such things, which for me was quite nonsensical. I was very, very upset by that because it really impugned on my integrity. I never came late to any of the meetings, nor missed board meetings when requested to, because I took my responsibility quite seriously as a board member. And of course, the sum total of it all is that I received another letter that said that I must give reasons why I should not resign from the board after the report that was designed and crafted by the company secretary. So, yeah, we didn't have a very good relationship with her, especially after that incident. And it's very clear that she does play a particular role within the corporation.
1 second. Where does the board derive its mandate?
From the Broadcasting Act.
Okay.
Thank you very much. Honourable Swartz, you've got 5 minutes. That includes both ways.
Thank you, Chair. Just to follow up on my colleagues' questions, the issue of you being summoned to appear before the minister, that must have been very unusual to you, because surely you are accountable in terms of the Broadcasting Act to the board and not to the minister in as much as any disciplinary action is concerned. Was that the way that you were treated? Would you say that that was not correct in terms of your understanding of your accountability as a board member?
Absolutely correct, because my impression was that I was going to have an engagement with the minister, probably talk about my concerns, my frustrations, recommendations and suggestions. I thought it was going to be a very cordial meeting. Little did I know that there was an ace up someone's sleeves.
And do you think that the fact that you voted or you abstained in the vote, was that counted against you subsequently in actions of the board? And would you think that that was a reason for attempts to get rid of you or to remove you from the board?
It could be one of those.
Just in that regard, you expressed yourself very strongly on the fact that you seemed to be steamrolled on that decision. And one would have thought that you would have voted against it, but you chose to abstain. Why would you abstain and not oppose the vote? Is there any particular reason for that?
I did express myself, sir, to say that I didn't want to legitimize an illegitimate process. I felt that the voting shouldn't even take place, for starters, because the process was flawed. And it's on those bases that I felt that I didn't want to have anything to do with it.
Just on the issue of the legal opinion, which was obviously the attorneys, which seemed to, in the view of certain persons, replace the public protector's remedial actions. And then we saw that there was a disciplinary action purportedly to be instituted against Mr. Motsoeneng. Can you explain to us, was that legal opinion? I noticed that the opinion says the board instructed us, and clearly you've said already that the board, it was only a certain member, you weren't aware of the instruction to those attorneys. But the disciplinary action, were you aware of that, and was the board aware of that, and the whole conducting of that disciplinary action against Mr. Motsoeneng?
The decision to, let me put it this way, the decision to appoint people who are going to manage the whole process, in other words, the chairperson and the evidence lead, etc., was done via round robin. But in the first instance, the original people who were supposed to have conducted that were changed. I think they were changed about 3 times. That then implied that something is not right. By the time the hearing set, as I did indicate, it was via round robin. It was very clear that a desired outcome was long planned, and the particular committee, for want of a better word, your prosecutor and chairperson, might have been briefed otherwise to make sure that the desired outcome is achieved. I found it very, very odd that he was acquitted on all those charges that were laid against him.
Thank you. Just explain to us this concept of the round-robin decisions. The round-robin decisions, was that a phone call to individual persons, or was it a telephone conference, or how did that take place?
Normally, with a round-robin decision, documents will be circulated amongst board members, which indicate that this is what is required, vote yes or no, and then transmit it back to the company secretary.
So there was no discussion or anything really? And you would consider that a breach of corporate governance?
There may be exceptions to the rule. If it is exceptional, under very exceptional circumstances, it can be utilized. But if it becomes the norm, then I have a problem with it.
Honourable Khoza and Honourable Loliwe, could I plead with you, excuse me, to allow Honourable Walters to go, because he has to catch a Commonwealth business, and then you'll follow immediately afterwards.
By the way, he caucused me before the meeting.
Oh, okay. All right, and after him, we'll then go back.
Thank you, Chair, and thank you for allowing me to go first. Mr. Mavuso, thank you very much for answering the questions where you have been doing. May I ask, just for clarity's sake, when the Minister came to the meeting unannounced at Sun City, I think you said you were at. Is that right? The Minister arrived at a meeting unannounced. You said?
In Machalis.
Oh, Machalis, sorry. Okay. So, it was at that meeting the Minister first mooted the proposal of Mr. Motseneng being appointed permanently as COO. Is that correct?
That is correct. In fact, how she put it, she mentioned that she couldn't understand why this matter has not been resolved until thus far.
Okay.
Precisely because she was able to, using her words, elevate a document from court insofar as the claim that the late Mr. Mvuzombebe had on the position of COO. And according to her, that matter is as good as resolved.
Okay.
And therefore, it's important that we finalize this issue and appoint a person permanently. And the sooner it is done, the better.
All right. Did anyone raise with the Minister the Public Protector's report and the findings against Mr. Motseneng?
No, we didn't raise that with her.
Why?
We believe that it was the responsibility of the board to deal with that matter.
Okay. All right. And so, do you think the Minister was unaware of the Public Protector report if she was insisting on Mr. Motseneng being appointed full-time?
Insofar as I do recollect, the Minister is a lawyer and therefore could have been aware or should have been aware of this.
Okay. Then at the meeting on the 7th of July, I think it is, where you were called, that Monday meeting, 7th of July, and it was put to you without prior notice that you were going to now vote on the issue of Mr. Motseneng being appointed full-time. You said the meeting took 5 hours from 6 p.m. to 11 p.m. Did anyone raise the Public Protector's report there?
The discussion was quite broad. It included the issue of the Public Protector, or the report of the Public Protector, amongst others, and the question around due process that ought to be followed.
The point I'm trying to get at, if the Public Protector has found in a report that a certain individual is unfit to hold that office because their qualifications are fraud, he committed fraud with regards to his qualifications, I don't see how the board could entertain appointing him full-time for that position. Do you see what I'm getting at? It should have been a fait accompli.
I agree with you, but as you can imagine, it was a majority decision that prevailed.
All right. And then you said the minister appeared as soon as the decision was made. Is that right?
That is correct.
11 o'clock at night.
Time of the night, yes.
So she arrived, that's quite amazing, 11 o'clock at night in the SABC building in Auckland Park. Just happened to be there at the same time.
Coincidence is just too good to be true.
All right. No, Chair, that's all my questions I wanted to ask. Thank you very much.
Bon voyage. Honourable Koza.
Thank you, Chair. Thank you very much, Mr. Mavuso. Based on your evidence, what you've reported to us, it appears as though the broadcasting policies weighted decisions seem to have been taken by Mr. Motsoneng, who appears to have totalitarian and imperious powers. Now, what I want to know from you, what would you attribute this to? Because this is a COO. This is not even a chair of the board. This is not even this is not even the chair of the board or the CEO of the company.
Honourable Member, this was an issue with most of us in the board, particularly when one picked up that this particular individual had relationships, very close proximity with chairpersons of the board, past and present. And that for us was a problem. And how he was able to make decisions, it's quite evident that it led to the undermining of the group chief executive officer, because the chairperson would defend that individual. It was problematic.
Can you confirm if Mr. Motsoneng did receive a commission for the multi-choice contract? And how much was that? Was that the board decision, if it did happen? A commission or bonus, I don't know, what did you call it?
I wouldn't know, ma'am. I saw in the newspapers that he received a bonus of 11.4 million. It's on this basis that I wrote the letter to say that we need to deliberate on these issues because they're quite important, very material, and require our urgent attention so that one can be able to verify the truth and the facts. I do not know. Up to now, even now, I don't know.
Now, during your tenure, the Auditor General reported that there was about 3.4 billion of irregular expenditure. And you served in the risk committee. Were there risks that you identified? Did you bring those risks to the attention of the board? And what were they?
The issues that relate to the findings of the Auditor General found expression in the Audit Committee. Some of them, of course, were raised by the Risk Committee. In other words, there was close liaison between the Risk Committee and the Audit Committee, and would receive what I may call a dashboard of issues that require attention from the head of risk to sensitize the board so that we can be able to take remedial action or appropriate actions. These have always been raised, and the matters would be put before the full board for consideration so that proper implementation can then take place or corrective measures could be exercised. Yes, we did take those matters into account.
I just need you to clarify the position around Ms. Chabalala and the chairperson of the board and the COO, given the fact that you said earlier on, if I heard you correctly, as the board, you were always there to support the executive. How would you characterize that relationship between Ms. Chabalala and the CEO?
CEO or the COO?
CEO.
CEO. It was a very let me put it this way. At the beginning, there was very good and cordial relationships. But things started to come to a head, particularly when the matter pertaining to the set-top box control hit the headlines. Remember that it is linked to the BDM, the Broadcasting Digital Migration Policy. And the policy was quite clear that encryption had to be put in. But it went against, or rather, this was not strictly adhered to, because at one point when the then Minister Yunus Karim embarked on an exercise to solicit views and embark on a public participation process, insofar as the encryption process was concerned, in one instance, I think it was required of us to be able to indicate what the position of the SABC was. It was still at the point at which we had taken a decision prior to that as the interim board to say that there shall be encryption. But of course, at the public hearings,
Please summarize, sir. Summarize
at
that.
the public hearings, Ms. Shabalala and Ms. Mokhobo did not agree. Because on the one hand, we supported the view that there should be encryption. Ms. Shabalala didn't. And it created tensions which then ensued from thence on.
Thank you,
very
Chair,
much.
and I'm sure you are happy that I am done.
Thank you so much, ma'am. Honorable Oliwe.
Thanks, Chair. Mr. Mavuso, you've painted a gloomy picture about the situation at the SABC. As a principled person, what kept you there despite all this for you to only resign here now in October?
Honorable Member, I'm not a quitter. I believe in fighting until you find sanity prevailing. But in this particular instance, I think I became insane myself. And I reached a point whereby I couldn't take it anymore. It was just too much.
Shame.
You are also indicating that at some stage when Mr. Makuve joined the SABC, chairpersonship of committees was shared amongst about 4 people. What happened to people who were chairpersons previously before his arrival? Was there a reshuffle or what on his arrival?
To give you a picture, Honorable Member, when there was a fully fledged board, chairpersonship was split amongst a number of members. For example, Advocate Tambingosi Bonagele chaired the Risk Committee, Professor Kumalo chaired the Human Resources Committee, and Mr. Lubisi chaired the Audit Committee. There were a number of people who chaired specific committees at that stage. But after their resignation and, of course, the unceremonious ejection of the other board members, the chairpersonship was then accorded to those who remained, excluding Mr. Naidu and myself. So it was the rest of the board members who remained at that stage. One would chair 3, others 2, etc. And it was clear that a line of divide has been drawn.
You have indicated that in many instances, recruitment processes were not followed. For instance, with the appointment of Mr. Hlaudi, you are drawing the picture. With the appointment of Mr. Aguma, you are also drawing the picture. Are there any instances you can share with us where this is happening, or it is only the 2 positions where recruitment processes are not followed for appointments?
Honorable Member, when Mr. Aguma was appointed as the Chief Financial Officer, which is his substantive post now, a due process had unfolded. There was an advertisement in the newspapers, there was shortlisting, and an agency was appointed to do that. There was a competence assessment process. We received those reports. Then there was an interviewing panel that was constituted. He was interviewed, and he was found to be a very suitable candidate for CFO. So insofar as he is concerned, I think due process was followed. I would have expected the same with Mr. Motsweni, but it didn't. And with respect to the others below that, in other words, your group executives, I don't even know what happened. Would receive a memo just before a press conference that these are the people who've been appointed into these particular positions.
Thank you, Chair.
Honourable Van Dam.
Thanks, Chair. Mr. Mavuso, you've painted a picture of undue influence by the Minister of Communications in breach of the Broadcasting Act. I mean, she burst through the doors close to midnight like an uninvited mother-in-law. And so you've painted this picture. Was there ever an instance where the President's name was invoked for decisions to be made? I mean, the minister is alleged to have said to the late Hope Zinde, "Ubaba loves Hlaudi, we must protect him." Are you aware of any other instance where either there was said to be an instruction from the president or the president's name was invoked in these decisions that you had to make?
Not that I know of him, no.
All right, thank you. And then you mentioned that into Mr. Maguve's tenure as chairperson, there were several meetings that were held that were in court. What were those decisions that were taken at meetings that were in court?
Usually, if a meeting is not forming a quorum, it will stand in for the next meeting, and then, of course, the decisions will then be formally ratified as and when it corrected.
Oh, I see. So when the meetings were in court, no decisions were taken?
There wouldn't be an implementation, at least.
In terms of the approval, firstly, of two decisions, one relating to the increase of Mr. Motsoneng's salary. So it was increased in 2014 by 1 million, and then the last financial year it was increased by a further 500,000. Was that decision approved by the board? And also the endless litigation the SABC has been engaged in protecting Mr. Motsoneng's position. Did the board approve the costs of that litigation and that litigation itself?
Insofar as the increases are concerned, that has not really been formally ratified or coming to the committees of the board. But the litigations, the plethora of litigations, I think it's a problem. The SABC has become a very litigious organization or institution, and I'm sure the Parliament will find expression in dealing with those matters. So how the approvals were made, you can leave the rest to imagination.
And needed to be clear, did the board approve litigation on behalf of Mr. Motsoneng?
The point I'm making, ma'am, is that in most instances, I would speak for myself. I would be against some of the decisions that would be taken, particularly around court cases. I did mention that there were a number of decisions that were taken via round robin. I would not approve of those, but invariably you will see a litigation taking place, giving an impression that it was a unanimous or a majority decision that took that via round robin.
Okay, sorry, Mr. Vos, maybe I'm not understanding you properly. It's not clear in my mind. I need to know whether or not for each time the SABC spent money going to court to defend Mr. Motsoneng, before that happened, was it put before the board, either by round robin or in any other manner? Was the approval of the board sought, or would you just read in the newspaper that the SABC is litigating on behalf of Mr. Neng? So I need to know, was it put in front of you, and would there be a majority decision approving litigation for Hlaudi Motsoneng?
On matters pertaining to Mr. Motsoneng, frankly speaking, nothing has come to the board to defend him or to litigate on his behalf, no.
Okay, thank you. Who would have approved that decision then? Would it have been the CEO, the CFO, if it wasn't the board, or Mr. Motsoneng himself?
Because it has never been placed in front of us, I wouldn't know.
Okay. Thank you very much, Chair.
Honourable Chauke.
Thank you very much, Chairperson. Mr. Mavuso, when you were appointed the board member, when you appointed the board member, already you had information of a malfunctioning of the board that we are appointed to serve on. Informed by the report that you make mention of, there was already a report available. So you went into this board fully aware that the scope, skid, and donor, as you said, in that environment. Now, I'm trying to understand the efforts and the, not only of yourself, because you do mention of a group of you who were against this scope, skid, and donor arrangement that is happening there. Have yourself met as a group separately from the rest of the board members? You make mention Professor Kumalo and the rest of those who were against this malfunctioning of the board. If so, can you explain what were the issues that you were dealing with in that regard? The other area I want to understand is that what is your view now that the entire board members have now resigned? We left obvious with the board does not exist anymore. Are you now satisfied that something new that can start will be able to assist and help the SABC, meaning that with everybody now that is gone, I'll take it that maybe through your influence, because you've been a fighter there, and everybody has seen the light at the end. That's why everybody has now resigned. Are you satisfied now that there can be some kind of sanity after this process that we're engaging in? The third one is the issue of the judicial review on the public protector's remedial action. That position, that decision, was it taken by the board, and you were part of that decision? Was there a resolution taken of the board to challenge the public protector's report? The last one will be, are you aware that ICASA has opened a criminal case against the chairperson and someone else? If so, can you just share with us those experiences and your view around the judicial review?
Mr. Jog, you've raised a number of points. If I do, by any stretch of imagination, omit others, please forgive me, but I'm sure you'll remind me. The matter pertaining to ICASA, I was not aware that they've instituted a case against the SABC. No, I was not aware. And with respect to the judicial review of the public protector's remedial actions, I'm not aware about it, that the SABC has gone to court to try and get that reviewed, because it really wouldn't make sense. It's a very clear report, it's quite pointed, and I think it will be after the fact. Usually one has to do that within, if I do recollect, within 90 days. If you want to apply for judicial review, either 90 to 180 days, I'm not sure. But if that is the intention, it's well past midnight. I don't think that would be able to be considered. What is it that needs to be done? What is my view insofar as the way forward around the SABC? Let me make one point very strongly. At the point at which there would be finality and there's no board at all, not even one man standing, I'm of the firm view that anyone who's going to be appointed onto the SABC board should be a person who's gone through an exercise to deal with being a board member. For example, IOD would have courses that would help people to be able to get to grips with the reality. And there must be a measure of integrity that goes into being a board member so that one can be thoroughly scrutinized in so far as the fitness is concerned. The only underlying point should be to serve the public of the Republic of South Africa, and it should not be about personal quiddities and self-aggrandizement, no. The final point, which I do believe is important, is that the rigor in which the engagement is going to take place in selecting people must be much more intense, and there shouldn't be any favors, or, for want of a better word, consideration because you are so and so and therefore this is what should be done. No. I don't know if I've omitted any of the questions.
Thank you, sir, even if you haven't, unfortunately. Ms. Killian?
Side to amend the memorandum of incorporation. Is it not properly on? Okay, I'm not speaking properly into it. Did you at any stage decide or discuss the need for an amended memorandum of incorporation? Are you aware that it was amended, and are you aware that the minister signed it? And what do you think about that? Because it appears to have cemented the usurping of some of the board powers in terms of its mandate. Can you please comment on that?
I did make the point right at the beginning, Honourable Member, that I noticed and I realized that it was signed by the minister, and for me it's quite problematic. It's an anomaly. It should have been done by the board, and whoever's going to come into the next board, I think it's an issue that will have to be taken into account. And I'm sure the Portfolio Committee on Communications will have to be seized with the matter and be able to give guidance and direction around it.
Thank you. Secondly, the role of the company secretary. It appears that the company secretary was unclear about the role that she's fulfilling to support the board members. Instead, she compiled a report at the instance of the minister. Are you aware of that report? Have you ever seen sight of it, accusing certain members of conflicts of interest?
The report, as I did indicate earlier on, was flashed by the minister's legal advisor when I was invited for the one-on-one. And I requested a copy and he flatly refused. I did request the copy, by the way, from the company secretary. She indicated that it's not her document, it's the minister's document, and that's where one can be able to get it. I've even given up on it. But suffice to mention that that role that she played was very divisive. It was very problematic, and it's not her domain. You can't have a company secretary assuming the role of a public protector of sorts and doing investigations nefariously and surreptitiously so without the knowledge of board members. It's unprofessional, it's unethical, and it cannot be countenanced.
Last question, Chairperson. We were informed by the Public Protector that her office compiled a comprehensive file for the DC of Mr. Motswaneng. Were you aware of it? Was it ever discussed? Or was it simply just set aside because of the Mkunu attorney's investigation into how to deal with an implementation plan?
I was not aware of that.
Chair, that concludes.
Mr. Mavuso, thank you very much for agreeing to participate, and to members also for being so disciplined with time. Sir, you are released. Honourable members, our next guest was scheduled for 4 o'clock. It is about 20 minutes to go. Now we can err on the side of, can I finish and I'll allow you to think? We can err on the side of caution, and I'm looking at my legal team, and wait until 4 o'clock and take this decision. Is that the route to go? No, oh, you want, no, I'm sorry. I'm sorry. Eh? Okay, no. No, it's fine. No, it's fine. Honourable members, no. Besides that, we'll wait until 4, and we will take a decision on that. And then there are 2 points that we need to make about next week's program. So we'll conclude today's business. In other words, the next agenda item at 4 will be to deal with the SABC's absence or otherwise. Conclude that one, and then deal with next week's business. No, I'm saying tomorrow's business we will deal with at that time as well. Yeah. So members should be back here at 4 o'clock, and then we'll deliberate on the SABC board. yesterday whether this requirement for documentation to be put into Braille was ever raised with him when when the AG presented their final report. The answer was no. That request was never put to the Auditor General. We repeated that question to the Public Protector as to whether there was a requirement or a request for her report when she presented it to be converted into Braille. She also said no. And similarly, we put it to ICASA. They too said no. Through our interactions today, we've been informed that in fact the SABC has got the machines to convert into Braille. We've also been informed that in the normal course of their business, this facility was indeed used to assist the professor in board meetings. That we know from input given to us today. And therefore, if the SABC board was here today, it would have been useful if they would have been able to respond to why is it that if these facilities are there and were purchased specifically for the purposes of assisting the professor, and after they had requested that we send documents in Word format, that they were unable to do so yesterday, and use that as one of the reasons for not deeming the proceedings to have any potential of being free and fair on the basis that the professor would not have had documents. So that we want to put on record, honourable members, and we can only speculate that because of that reason, or mainly because of that reason, the SABC board and Professor Maguve in particular did not present themselves to this committee today at 4 o'clock as agreed to. Now, honourable members, we have two options in light of where we are now. The first option available to the committee is to proceed in his absence. As stated in the notice of inquiry dated the 17th of November 2016, which contains the following words, and I quote, and this was sent to all potential witnesses. Should you fail to attend the hearing, the committee will proceed with hearings in your absence. That is option one. The second option available to the committee is to issue a summons in terms of Section 55A of the Constitution, read with Section 14(2)A of the Powers and Privileges and Immunities of Parliament Act 2014, for Professor Maguve in his capacity as the chairperson of the SABC board to appear before this committee as a witness and to deliver the documents which are still outstanding from our summons of the 24th of November 2016. Those are the two options that we are faced with now, honourable members. And mine is then to request for you to indicate which of these two options we exercise so that we're able to proceed with these hearings one way or the other. Having done that, I would want to address the issue of documents, but let us deal with this one first, and then we'll deal with the issue of documents. Option one, we proceed as we had highlighted in our letter dated the 17th. Option two, exercise our rights per the Constitution and summons the professor to appear before this committee as a witness. I seek your guidance. Could I start with Honorable Mokoena, followed by Jabu Matlangu, Honorable, followed by Swartz, Honorable, followed by... Does everybody want to speak on this matter? All right, if everybody wants to speak on this matter, can we then also agree, honorable members, that it can't be more than 2 minutes, your input? We'll summarize that and take a decision forward. We'll start with you and go in the same fashion that we've been working earlier on. Honorable Mokoena.
No, Chair, I wanted to say that also it must be on the record that in the meeting yesterday when they walked out, that some concessions had been made by the Chair himself that we would make an effort to convert the documentation in this inquiry into Braille. That is one. Two, that the chairperson of the SABC has been to the Portfolio Committee of Communications, and there was no demand for Braille documentation when he came before the public hearing. That's another one. Now, on the issue of what's the way forward, I think we must exhaust all options that we have, and I think we must send summons to him as per our rights, because I think it's important for us to hear what he has to say. But I'm also of the opinion that because this is an act of defiance to both himself as a normal citizen of this country, but two, as a chairperson of the board, which is a parastatal. And I know I stand alone on this one, but I want to reiterate the point that it is time that we ask Mr. Maguve to give us reasons why he should not be dismissed. For many reasons, including trying to sabotage these processes, which are in his favor, and which are in the documentation that run the institution that he's a custodian of. Thanks, Chair.
Chair, Mr. Maguve, Professor Maguve had, we actually had scheduled him for a later date. He specifically requested that he appears today. We granted him the opportunity. Now, indeed, he's decided not to honor the appearance. My view is that he's accountable, together with his contingent, to Parliament South Africa, to the peoples of this country, through the body of the elected persons, in this case, the National Assembly. There is no way we will allow anybody to defy Parliament. I think we must make an example. And my recommendation is that summons be issued. We can be flexible about when we allow him to come, either the original date we had set, or allow him, if we issue the summons today, and we are able to reach him overnight. If he's still in Cape Town, it will be near, but I mean, we have mechanisms if he's in Pretoria or elsewhere in the furthest part of the country, that he be located and he be served with summons, and that he appears as the last presenter on Monday. I'm saying the last, so that we allow him sufficient time, because I would have preferred that, because he's at the center of the matters, that he gets more time than the rest of ourselves that we've had. Thanks, Chair.
Thank you, Chairperson. I believe Professor Maguva can provide a lot of clarity to a lot of evidence and a lot of issues that have been raised today. And so I look forward to hearing his evidence. It seems when he was appointed to the board, there was a lot of improvements, but we now see a lot of issues that have arisen where allegations have been arisen that it's almost a dysfunctional board, and we'd like clarity from that. And also, obviously, he will be able to be assisted by legal advisors should he require that at a time he can be assisted by them. So I would support the issuing of a summons. I believe that it would assist this committee in reaching a finality and reaching a conclusion once we can engage with him on a number of the issues which he has, which have been raised, a number of concerns. As far as the documentation is concerned, there's nothing to prevent us as well. Should there be a request about commercially sensitive information, we could consider a request in those lines. But as I understand, no such request has been received as yet. So I would support you as well that the summons also relates to documentation that is outstanding. Thank you, Chairperson.
Chair, I want to align myself with the first three speakers and support option 2. Chairperson, I don't think that we can allow a situation where we allow this state of paralysis where the authority of Parliament is being subverted. And in this case, Chairperson, I honestly think that we should use the summons and whatever other legal means possible to get him before this committee so that we can get clarity on these issues. We need to restore the integrity of Parliament. We also need to ensure that the state parastatals are doing the work that they are supposed to be doing. And that would be my submission, Honorable Chairperson. Thank you.
Thanks, Chair. Chair, I support the previous speakers. It is disappointing that somebody who says is still a chairperson of the board decides not to come to Parliament because we have an oversight responsibility over these entities. So it's good that summons are going to be issued to him because we want to hear what he's gonna say about the state of the institution he is in. But I want to appeal to Honorable Mahlangu that let's rather use Tuesday because according to our draft program, on Tuesday, the last group we are calling is at 2 to 4. So we put him in the 4 to 6 slot on Tuesday. Thanks.
Thanks, Chair. I don't think we can proceed because this is supposed to be an inquisitorial process. We're supposed to gather information. So if the person who is purportedly chairing the board cannot be here to give us that information, I don't see how we can proceed. The second point is that Prof. Maguve went to court alleging that some members of this committee had preconceived notions about what the outcome of this process. We said we're coming here with an open mind. Come and tell us, give us different information. He's been given the opportunity to come clear his name. He has not taken that opportunity. He's disrespected that committee. So summons.
Chairperson, I agree with the members that are agreeing with you that we need to proceed and issue summons. And I think you have put it quite very clear that all arrangements, all efforts were made to accommodate Professor Maguve. You can see the seat there, it's arranged, it's empty, the prof is not there. So my take, Chair, is that this summons must be issued, invite the prof to appear via summons on Tuesday, as members have just put it. Then we'll take it up from there. But if the prof fails to appear again, Chair, and that's why yesterday when we were speaking, we then said the legal team should advise as quickly as possible. The sheriff or the police have to be ignited, or either we have to go to court. That process needs to be clarified because this is a very serious issue, Chair. There is no way that an individual or a chairperson of a board elected by Parliament can defy Parliament. South Africans want to hear what are the issues around SABC. Our position, I think, is very clear, Chair. Let Prof come, appear, we'll arrange everything for him. All the systems are in place. So let's engage with Prof. That's the appeal I'm making again, Chair, that for the sake of progress, for us to correct what is happening at SABC, we need this cooperation. And it's now getting to a point now we are issuing someone, which is not correct, but it had to happen now. So that's a position I'll agree with colleagues that we don't have any other option now. And I will take it that wherever Prof is, he can hear us when we speak because he listens to TV, he listens to radio, he can hear that we are now at the point that we are now having to issue summons and there's no other choice.
Thank you, Chairperson. It is regrettable that we have to do this, but I align myself with my colleagues. The SABC, as a state-owned company, is a creature of law. All of us have to perform our functions and responsibilities in terms of the statutes and the Constitution, and that makes no exception for anybody who serves in any board. So therefore, I would align myself with this request. Chair, just lastly, I think it is just important for the record. You have indicated that we believe that that is the reason that they left. As far as we are concerned, that's the only reason was the matter of the Braille, because it was upon that point that they left this meeting, and therefore it must be clear that it was the issue of the Braille that prompted them to leave this meeting yesterday and walk away. We believe we want to invite them back, and if this is the mechanism to get them back here to answer on further probing questions, that would assist the committee to complete its work. Thank you, Chairperson.
By direction of the ad hoc committee, could we ask the legal team to put into motion that is necessary so that the professor appears before this committee on Tuesday? So that deals with the first part of it. Thank you very much, honourable members. I just want to very briefly deal with the second part of it, which was also central to our business. Honourable members, we would have, as South Africans, all benefited if, in fact, the SABC board was present here today, because we, contrary to their letter indicating these matters were either not available, or documents were either not available, or were of such a nature that it would have compromised the commercial interests of the SABC, we had different views. We can't take those views as gospel. It would have been so useful if they were here, because they would have countered those views. It's important that they should have countered those views, honourable members, because the legal representative of the SABC board, or the legal representative of Professor Maguve, in writing sent communication to this committee stating the reasons why they would not want to provide those documents. And we insisting that those documents should come. So it would have been useful for us to have that discussion with them today. But a very worrying factor, honourable members, is that one of those documents that we requested was the SABC skills audit that was done by Price Waterhouse. And the letter from the legal team dated the 6th of December indicated on page 2.2.4. The following documents will not be provided on the basis of privilege, and its disclosure may negatively impact on the commercial interests of the SABC. And they listed 5 or 6 documents. One of those documents is the skills audit done by Pricewaterhouse. Honorable members, on the 30th of December 2014, of January, I beg your pardon, on the 30th of January 2014, Ms. Teresa Geldenhuys communicated with the Portfolio Committee of Communications, presented them with that very document we're talking about in preparation for a Portfolio Committee meeting on the 4th of February. Let me repeat. On the 30th of January 2014, Ms. Teresa Geldenhuys communicated with the Portfolio Committee on Communications and sent them that document in preparation for a Portfolio Committee meeting on the 4th of February 2014. 2 years later, they say to us that that document is of a sensitive nature, and we as well are an equal Portfolio Committee of Parliament. Now I'm looking at the legal team, and I'm requesting the legal team to go and do an investigation and report back to us by the end of the day tomorrow. In light of the fact that we've received this letter from the lawyer on the 6th, and the fact that this very document was presented to this Parliament on the 30th of January, is this action of yesterday, does it not border on contempt of Parliament? So that when we get that opinion from you, we are able to take even this matter forward. I thought it was important to raise that point, honorable members. That then concludes this part of it. In terms of our proceedings for tomorrow and beyond, let's start with tomorrow. At 9:30, tomorrow, Friday, the 9th of December, 9:30, we are scheduled to meet ex-board member Chris Naidu, or resigned board member. I don't know if it's ex or resigned. I'm not sure what the term is. Ex-board member at 9:30. At 11:30, we are scheduled to meet Mr. Phil Molife, who is a former acting GCEO. And at 2 o'clock, we are scheduled to meet Mr. Tsietsi, who's a former group executive risk and governance. That's in terms of the program tomorrow. Honorable members, on the 12th, Monday the 12th, we had scheduled a Mr. Jabulani Mabaso, who is a former group executive human resources. And we came and reported back to you that this witness requested a hearing in camera. And you indicated to us that we should go back and go and renegotiate. We are now at a point where we're 3 days away from his hearing, and the situation hasn't changed. We need your direction. Secondly, on Tuesday, the 13th of December, at 11 o'clock, we have scheduled a Mr. Shushu, who is the former head of procurement. You'll recall the last time that we gave you an update, we indicated that this witness felt strongly that his hearing should also be in camera because he's on the job market, and it would... Oh, I beg your pardon. Mr. Mabaso is the job market. I beg your pardon. Mr. Mabaso is the job market. That was the rationale. Mr. Shushu... Mr. Shushu does not want to be televised, and therefore, by extension, I would read it to mean that he also wouldn't want the print media here. So those are two matters, honourable members, that you asked us to go back and work on. And we are giving you an update on those two. And you need to, either today, or we can even do it tomorrow, if you go and apply your minds overnight, we can decide tomorrow how do we proceed with these two so that Cindy and her team are able to put the wheels in motion. I know I'm ambushing you on those two, but I don't think it will be a train smash if we applied our minds overnight and discuss the way forward on those two particular ones tomorrow. But then again, I defer to your wisdom on those two particular matters. Honourable Chauke, Honourable Swartz, Honourable... Everyone wants to speak. I like it when everybody speaks. Let's start in the middle. All right, we'll start in the middle. We'll start with... No, you said we must start in the middle. We'll start with Loliwe, move to Khoza, come to Honourable Van Dam. We'll then go to Chauke. We'll then move to Honourable Killian. If you don't want to speak, you'll just pass over. We'll then move to Honourable Swartz. We'll then move to Honourable Matlangu, and we'll give the honour of closing to the Right Honourable Mokoena.
Thanks, Chair. Chair, our intention as this committee is to get as much information as we can access. I think the two witnesses have tried to move the first step. Not that we are saying they are supposed to hold us at ransom when we want information from them. But where I'm seated, I'm of the view that let us grant these two their wish, the one who does not want to be on camera and the one also. In fact, both are saying the same thing but in different languages. But ultimately, it's the same thing. That's where I'm seated, Chair. Unless you want us to reflect on your proposal of slipping over this.
No, I thought you were going to talk on the proposal. I don't know if you get into the debate because I've ambushed you.
Okay.
It's not a light matter, honourable members, because it sets all sorts of precedents. Okay. If you want to finalize it today, your servant, I will allow you to do it. I just thought that maybe we'd want to go and think about it and do it tomorrow, but I'm at your mercy. The second person was honourable.
Fine. Let me finish, Chair. Then, in light of that, Chair, allow us to seek mandate on the matter and come. Allow us to go and seek mandate and come back on this issue.
Chair, the most important thing about this ad hoc committee is that it is so united. And I think it's important that you give us an opportunity to think over this matter so that when we come back tomorrow, we would have applied our minds and we would have found each other if needs be. Thank you, Chairperson.
Thanks, Chair. I've expressed myself on this before. I said earlier that if it's someone who isn't no longer in the employ of the SABC, if they feel under threat or they feel that their lives are under danger, then we should do it on camera. But if it's someone who is an employee of a state institution, they absolutely are under obligation to do it in public. I mean, we're dealing with people here that have mafia tendencies. You'll remember there was the death threats. We saw Mrs. Mohobo, she looked visibly traumatized. So I wouldn't want to put undue pressure on people who are no longer in the employ of the SABC. So my suggestion is let's grant them if they're not employed by the SABC any longer.
We're going to sleep over it, Chair, because it's not only the question of granting. We need to again understand the kind of a witness. What is it that we're going to expect? So that is quite a detailed thing. So my proposal, I want to agree with colleagues that says, let's sleep over it. Tomorrow is less 24 hours to go. Tomorrow morning we can then have a position. Because even the issue of the camera, vis-a-vis media is somehow in different phases. You may have a camera, you may have a print media and all of that. So we need to check those things that we are sure. We cannot make a conclusion and say this person in fact does not want anything. For us to go in committee, you must know that it sort of, we have been very public throughout, and the public interest comes into in the process. So that's why I'm saying that let's sleep over it, let's come back. We have created an expectation outside there, not because I want to force people to speak public, but to be able to balance that particular watch call. So that does not create something that people come tomorrow and then say that in that closed meeting, something will have happened. You know, we must be able again to say, how do we communicate what has been said in closed camera properly, so that members of the public are informed accordingly of that in-camera meeting. So I think let's sleep over it. We'll come back. We have to apply our mind and clear politics that we must come out of the, which means that the way forward of it must be very clear to everybody.
Thank you, Chairperson. I will await that we discuss it tomorrow after we've slept over it. But secondly, just clarity, is our program therefore with the representatives of the SABC 8 that was scheduled for Monday, is it no longer the same? Or are they still coming on Monday afternoon? Also, we had on the list on Monday...
Honourable Killian, let's deal with this one first, okay, and then we can deal with the rest of the program. Just on this one, otherwise we'll cloud all sorts of things. Just on how we proceed with these two names. If that's it, then we'll certainly come to your point immediately hereafter. Honourable Swartz.
I think, Chair, there are various factors that one needs to take into consideration: the interests of the person wishing to give evidence, the public interest. It's almost similar to a court application for access to media when a court is having hearings. So I think it is wise for us to consider these issues. They're far-reaching, what the precedent that we will be creating. And so I support the suggestion that we consider these issues and come back tomorrow and finalize this issue. Thank you, Chairperson.
Chair, thank you. I'll share the view of the colleagues that are saying let's sleep over it, because indeed, from what Madame Van Damme was saying, it is clear that both the individuals are not employed in the SABC, but also you have a public interest, you have a personal issues, you've got public interest. My view will be that perhaps once we sleep over the matter, because I think we've built a relationship with media, just touch base with them as chair and hear them out, try and coerce them if we will eventually accede to their demand, so that at least we build that cohesion as to how then are we going to give the feedback. I think those things are crucial for me.
No, Chair, the Bill of Rights gives people the rights to privacy, and I think we must grant them, but I would concur that maybe we should go think over it and discuss it tomorrow. Thanks.
It's either we're close to Christmas or there's a miracle happening here in Parliament. Never seen such unitedness from political parties before, but yes, once again, unanimously, please go and think about it and the potential precedent-setting and or domino effects that it will have, and we will try and find some time tomorrow to finalize it, so that Cindy and her team then do what needs to be done.
that maybe you should again ask the legal team, because a closed meeting, you apply for it. Maybe they'll have to look at that whole process of applying, because we operate like any other committee, obviously, with a special, interest. But we have to look at, because normally you apply to the speaker for a closed meeting. So I think we'll have to look at those issues.
Because they're part of our support staff, I think they've heard you. If you guys can also advise us on the option, if we eventually decide to go close, what are the practical things that we would have to do? If it's not practical, then that's another decision, because we really want to be practical. We want to be sensitive to concerns raised by potential witnesses, but at the same time, we also want to be able to say to South Africans that we have got nothing to hide. So it's that balancing act that we need to carry out. Honourable members, once again, thank you very much for... Before we do that,
thank you, Chair. I would like to just make one request for the committee to consider. It might not be today, it will be tomorrow. In the interest of fairness, and you would have picked up in today's proceedings that the witnesses, to a large extent, made reference to Dr. Ngobane and Ms. Chabalala were the former chairpersons of the SABC board. And I would love to suggest that the committee considers the two being added to the list of witnesses. Thank you, Chair.
agreed? Nipuzani, ne? All right. Cindy and her team, I feel sorry for this team. Please, can you do the necessary to offer invitation to former chairperson of the SABC board, Ellen Chabalala, and the former chairperson of the SABC board, Dr. Ben Ngobane. No, but Baba, we're not going to finish if we do it that way. Okay. Yes.
No, Chair. Bear with me, Chair. There's a point that I raised the other day when we were dealing with the issue of archives. And the point was that because the end user currently of the archive is multi-choice, I then made a proposal that maybe let us consider inviting multi-choice to explain, because no one is explaining to us the status of the archiving. I then thought that that point was noted, and maybe you should express yourself on it so that either we take a decision that we don't have to call them, but I thought it was a very important point that I made last time.
All right, I will sleep on it. Can I come back with that tomorrow? I'll go to the legal team. I'm sure there's many ways of doing this, as you say. There's not only one player in this transaction. And somebody spoke about the competitions board yesterday, and all those competitions commission yesterday. So I'll sleep on it, and then I'll come back and I'll put onto the table a proposal as to how we deal with it. Also bearing in mind it's one of the documents that we also have on our list of summons. So we look at all those things and come up with a proposal. But we don't want to overload our program. Our time is the 28th of February, honourable members, and let's be practical that we can't have endless witnesses. But these three, we certainly will come back with some sort of an answer tomorrow. To everybody that has been here with us throughout the day, thank you very much. We meet in this venue at 9:30 tomorrow morning.